Welcome to SpringLaw SpringForward Legal Updates webinar series. This series is designed to provide a comprehensive legal overview of key issues related to employment law and human rights in Ontario. SpringLaw is a virtual employment law firm advising on workplace legal issues for employers, employees, freelancers, and executives from a wide range of industries. We hope you enjoyed today's webinar and find it useful and informative. To reach our team, please visit us at springlaw.ca. And now to our presenters.
Welcome, everyone. First of all, to episode 69 of our monthly webinar from SpringLaw. Today, we're going to talk about performance management, terminations and severance, and what employers often get wrong. We're always aiming to keep this very practical and action-oriented for you. So hopefully you can leave the session with some extra tools on how to go about doing this. I'd like to introduce us. I'm Lisa Stam, the founder and managing partner of the firm. This is my colleague, Jessica Paglia, who has been with us for a bit and is exceptionally good at advising our employer clients, I have to say. What was that, Jess?
I said thank you.
Welcome. If this is your first SpringLaw webinar, welcome. We are a virtual Canadian law firm focused on employment law, contracts, and litigation, and we regularly host these monthly webinars to share our insights with our employer clients. As we go through the presentation, please feel free to drop any questions into the chat, and we will keep an eye on it as well as we move forward to the end of the session, and try and answer questions as we go as well. You can also download the slide deck themselves from the software and take a look at them after if you'd like. And then if you'd like more resources, please come to our website, springlaw.ca, where you'll see our weekly blog. You can sign up for our monthly newsletter and learn more about our subscription program and other innovative programs for our employers. Before we start, we of course always want to acknowledge that the land on which we operate is the traditional territory of the Anishinaabe, the Haudenosaunee, and the Huron-Wendat people, and the Mississaugas of the Credit First Nation, who have stewarded these lands for generations. We recognize that Indigenous people lived and thrived here long before the arrival of the settlers, and we acknowledge the lasting impacts of colonialism. As part of our commitment to truth and reconciliation, we strive to learn, unlearn, and understand the history and effects of these wrongs, and we are grateful to be working on this land. We are giving legal information today. We are speaking generally. None of this is applied specifically to any of your facts in your workplace, and it is not legal advice. Here is a longer disclaimer of how we are only sharing legal information today. Okay, so what are we going to cover today? Let's start getting into this. Here are the basic topics we're going to go through. Why terminations do go sideways. As a preliminary comment, that is one of the most expensive moments in every employment relationship. So this is why it's worth having a whole session on this. So why does it go sideways? How does performance management fit into all of this? How to terminate employees the right way? What are severance, contracts, and enforceability? What's the recent case law and legislative changes in this? What are some high-risk scenarios that employers often underestimate? And then what are some practical takeaways that you can use immediately? So Jess, why don't I hand it over to you to get going?
Thanks, Lisa. So now we'll go through some key points on the next few slides about why terminations go sideways. So where do terminations go wrong? Well, most employers are not trying to cut corners or do anything wrong intentionally. But the problem here is that legal risk usually doesn't come from intent. It often comes from just the process itself and what employers do or what they fail to realize they have to do or they should do. And so often the potential legal risks start long before the actual decision to terminate through process management or things like that. And we'll go through all of those things today. As well, small missteps, so things like timing, documentation or lack thereof, or messaging, either verbal or written, can quickly turn into more expensive outcomes or raise the price of a termination quite quickly. And once lawyers get involved, either on the employer side or the employee side, on the front end of communication, the issues and the costs tend to compound quite quickly. So next, we'll go through performance-based termination specifically.
Sorry.
No, that's okay.
Let me find my button there. Okay.
Okay, so specifically, thanks, Lisa. So with performance-based terminations, performance management, if that feeds directly into the termination decision itself, then the decision really could influence or determine exposure. And so when performance management is weak or inconsistent, especially when choosing to rely on it in the event of a termination, it undermines your ability to rely on it in order to execute the termination. So when a termination is handled poorly, whether it's through timing, messaging, or process, as discussed earlier, the costs almost inevitably raise. And the key thing here to remember is that by the time you get to that exiting stage or that termination stage, you can't really undo earlier mistakes. It's quite difficult. So for this reason, it's really important to have a game plan at the outset. So next we'll go through the employer myth. So the employer myth is, we can terminate without cause and performance doesn't matter. So we hear this all the time with employers, we can terminate without cause, so we don't really need to document, or, performance management doesn't really matter. While it's legally true that an employer is able to terminate without cause, and it's a completely different process than terminating for performance-based reasons, it's not the same thing as being low risk. Courts do care about fairness and credibility when it comes to termination and performance management, and they look quite closely at how the decision was made and the documentation leading up to any decision to terminate. The paper trail always matters. So if performance issues do exist, it's important to document them, and you want them reflected clearly and consistently, and not just arising for the first time at a termination, during the termination, or thereafter in discussions. So next I'll pass it over to Lisa to walk us through some considerations for performance management.
Okay, great. Thank you, Jess. So as Jess said, how you do this really has a big impact on all of this. In the world of employment law, you can either fire for just cause or without cause. It's one or the other. And it's kind of like being pregnant. You're not just a little bit pregnant. You're either you are or you're not. And so it's just cause or not. But that doesn't mean that paying attention to performance management isn't very important with all of this. And it really comes down to risk assessment and helping your workplace save money and headaches down the road. And, where possible, trying to preserve some sort of relationship with ex-employees. So in terms of the headaches and the cost piece, courts really do care about fairness and credibility, and they look closely at how the decision was documented. So that paper trail really matters. So if any performance issues do exist, you really want to have them reflected clearly and consistently, and not showing up for the first time in termination. So why does it matter? It may matter because it may shape how a termination is judged. So if all of a sudden, you are showing up and there's all of a sudden a termination out of the blue, and it's not any sort of business restructuring, if nothing else, it amps up the emotional temperature of the parties and the employee, and it ends up just creating much more of a difficult negotiation for the exit package. So on to the next point, it does determine leverage in negotiations, and why having appropriate performance management so that there's no surprises at the time of termination really matters. For for the small number of times that employment law turns into an actual court trial, it affects the credibility with the courts and councils. So people are paying attention to the employer's behavior throughout this, and if there is two sides to the story, and there is an ambush at termination, you can be guaranteed that the employer's position is going to be much weaker when you're doing any sort of advocacy to support the termination. It also often decides whether a claim is settled or escalates. So again, surprises at termination really do not land well with most employees, and it really leads to far more headaches than necessary. So what are some common performance management failures? A key thing is, is that issues are raised too late. So asking someone to improve their performance and then firing them the next day obviously is a big problem. Giving vague or inconsistent feedback is a challenge. Make it measurables and tangible and specific examples when doing the performance reviews. For anyone who's an HR professional in this session, you know exactly what I'm talking about, and I have no doubt you're frustrated with the managers who are not maybe giving the same specific metrics that you're trying to coach them to do. So this it can become an organization-wide challenge, but having really clear, consistent feedback, preferably written, is always very helpful. If there have been some performance issues, following up with people so that they and written follow-up, not just casual conversations in the hallway, having a written follow-up of further to our discussion, here's what we talked about and what we're going to work on going forward. An email can really save the day. And for owner operators and small businesses, there isn't a great big HR department to do all these things. So an example of a shortcut really is a simple email that sets it out and lays out expectations. So over relying on these informal conversations, people will remember those conversations differently. And if they happened a year ago, no one will remember them. So having things written is really important. And then having support inquiries as opposed to discipline inquiries with your team, and giving efforts to train so that they can improve their performance or improve whatever is the performance issue that they're having. Coming to the conversation with a bit of curiosity and how can we help is a very different conversation than this is all the ways you're messing up and you better smarten up. It's a total one is very patronizing and not welcomed, and it doesn't actually lead to success. And when we work on the employee side, I can tell you we hear that side of the story where they're horrified, embarrassed, and angry. And so it does not nurture improvement. So these performance management conversations can really along the way make a very big difference at the end in how people are responding to any sort of termination. So an issue we run across frequently is the nice review problem, and it deserved its own slide because it is such a frequent issue. Many people don't like conflict, and they don't like to say bad things to someone. They feel awkward about it. If you have some newer managers or more frontline managers who are doing this, they don't enjoy doing this. Or if you've got some big age differences, a younger manager speaking to an older experienced worker, there's all kinds of reasons why people just say nice things in the review, even though in the back of their mind, they're like, this guy is actually not very good. And here's the 12 things that I didn't like about his performance. But you still need to say that, because if a termination comes down the road and you try and pull out all of those comments, it's a really big problem. The employer their credibility is gutted when you're doing any negotiations. If you're able to point to conversations that you've had with an employee where they had an opportunity to improve, it is a total game changer when it comes to negotiation leverage down the road. So again, the ambushed terminations are really a big challenge. Consistency is very important. So if you have a similar issue of different employees, let's say absenteeism or lateness, people showing up 15 minutes after they're supposed to be there. Obviously, you cannot only address it with the one person who's not a great performer otherwise, but the person who's a superstar, you let that go. That consistency is going to bite you later on, and really trying hard to have that consistency across the board is important. It also is a big foundational part of discrimination claims, that inconsistency. So if you are treating anyone differently, even if it's because their tactical performance is terrible, if there are any protected grounds involved, any human rights grounds that might be at play, or any recent, return from leaves, or any recent occupational health and safety complaints, all of that can start to taint what was otherwise just a normal performance issue. If there are any exceptions to how you're applying any particular standard, definitely make clear what the justification is for, justify why there is the exception, and then just be aware that any inconsistent enforcement really weakens an employer's position in the first place. Finally, when it comes to hybrid and workplace, there are, we're obviously big fans and advocates of the virtual workplace. We have been virtual since 2017, but some of the tactical things that I think an employer needs to be more mindful of is that in a in-person location, there's chit chats in the hallway, or if you're going to a physical meeting together, there might be conversations there, or things come up in person, and those informal conversations in an in-person environment, we know that they need to be converted to writing or formalized in some way. In the same way, in the remote world, if there's conversations in the chat, your Slack, your Teams, your whatever it is, your tool, or email, if it's just a conversation back and forth without a specific, no, this is actually a really important part of your performance that you must improve, it becomes too informal and unclear and ambiguous and difficult to enforce. Another important point in the remote and hybrid world is it's not a huge rollout in Canada yet, I'm happy to say, but this idea of electronic monitoring of people behind the scenes and checking their keyboard strokes and seeing how they're working, that is not the same as performance management. That is merely monitoring if they showed up. And so unless you're only looking at attendance issues, it has nothing to do with performance management. So be mindful that you may get all kinds of data out of your monitoring tools. You still need to do all the same performance management stuff, even if you might use some of those algorithms for, to support some of the conversation, but it really isn't the same thing at all. Saying nothing it can get interpreted as approval. And in the remote world, in our firm, we make a big deal out of everyone has to put their own hand up and identify if they have an issue. We really try and put the onus on the full team to take responsibility if they have a tool that's not working, or their computer's acting up, or there's no visibility otherwise. And so that accountability has to be at all levels of the organization. But when nothing is said, whichever direction, vertical or horizontal, if there's nothing being said, then we all just assume everything's tickety-boo, or you're approving the process or the behavior. And so ongoing communications about any concerns, it just always is an important part of being able to handle any of that behavior in a performance review later. Okay, so termination decisions. The real question is not only can we terminate, but should we terminate now? Timing really matters. If they're badly timed, do they just turn into a claim? So badly timed in terms of, did this person just come off a leave? Is this person, did they just talk about, disclose that they had a disability yesterday, or that they're very stressed out, but they haven't quite put a label on what's going on, but that there's all kinds of challenges. Even something as simple as, is today their birthday? Don't fire them on their birthday. That's a really bad idea. Wait till tomorrow, And so timing really does matter on when you terminate someone. So being mindful of that is important. Rushing it is really a big problem with creating liability as well. If you are firing someone because you're emotionally reacting as opposed to responding to a situation, you can just anticipate there's going to be all kinds of issues. Every termination takes a bit of planning. You need to, check in with your IT company, if you have benefits, talk to your benefits people, get the documentation lined up, get all your ducks in order before you actually conduct the termination. And so when we see terminations that were an emotional reaction, usually that goes hand in hand with no documentation and all kinds of messiness. So just a calm, planned termination saves so much money and headaches at the end of the day. If you do that really well, you don't even need to ever talk to us. So doing it very calmly, I think it really makes a big difference. Again, we talked about timing and just, any sort of reprisal if they just made a health and safety complaint, or if they've just done some sort of statutory protected leave. Definitely make sure that you're not terminating in a bad timing. That just adds so much cost to everything. The other thing to be careful of is that the language of why you're doing the termination, it has to match the story. Right. So if the whole environment was and the relationship was going a certain way, and then all of a sudden you have this brand new reason why they are being terminated, even in a with cause termination where you can absolutely fire for no reason, you can just fire people in Canada and give them their reasonable notice period. But when there's inconsistency, you start to attract all kinds of potential human rights or other claims at play. And certainly, if this is a straight business restructuring, you're selling off a division of the company, and it's a straight business restructuring, a lot of this is a lot less important because you don't need to worry about all these other things that might come into the termination to feed an employee's claim. But when it's a one-off, without cause termination, if there's a big context, usually people don't fire a person out of the blue, right? There's usually a story leading up to this. Make sure that the language and the story are all matching. If you have any internal emails that are contradicting why, be aware that those could be ordered on disclosure if litigation arises. So there's no hidden record, so make sure that you're keeping all of that consistent. And then ultimately you can call it without cause and say, here's a giant package of a reasonable notice period. That will not shield bad behavior. If in the same breath you're discriminatory in any way, you're racist, sexist, homophobic, or demeaning around their disability, you can't just call it without cause and not expect also this whole other layer of human right damages attached. So it won't completely shield you. So what breaks an otherwise defensible termination? So if you otherwise had all kinds of ducks in a row and there was just a really legit reason why you wanted to let this person go, having very sloppy communication, with inconsistency in the actual meeting when you're conducting the termination, avoid over-explaining the reason. We always tell employers, keep those termination meetings short and sweet. No one will be happy, so don't try to keep talking until everyone feels good about this terrible decision. Usually the employee is upset, whether they wanted to be, whether they were looking to leave or not. They're now the dumpy. No one's happy about that. They're upset. Kind people tend to over-explain the reason to try and get to an end where we all feel good. It'll never happen, so accept that. Make sure you have all your documentation ready to go, have a proper termination letter and release, think through what the package is that you're offering and have that all in front of them, and then keep that meeting itself short and sweet. If you're doing it by video, have an email lined up ready to go to hit send at the end of the meeting that will share the documentation. These termination meetings, 5 to 10 minutes, they don't need to be longer than that. Because the decision has been made and it is what it is. So one little practical trick, if you're doing it in person, at the end of these termination meetings, there's this awkward, okay, so you're fired and I guess I'm fired and like, now what? So have a way, plan ahead what your one-liner is to end the meeting so that you can close this awkward moment. And if you're in person, the best thing to do is simply stand up it signals to the room, okay, I guess we're done. And it works 100% of the time. On video, come up with some, like, plan ahead already what your closing line is. Like, okay, so if you have any other questions, let's wrap this up. I know this is difficult. If you have any other questions, just reach out to us, but let's wrap up this meeting now. See you later, and let them say goodbye, and then click. And it feels hard. It really is a hard thing to do. I've never met anyone who loves doing any of this, but long termination meetings are where all the emotions come out, and they're usually a big disaster. Jess, did you have anything else to add to this around the messaging and the meeting and just the overall performance management before we jump over to the next topic?
No, I think you covered it well. I would say we also suggest that there's more than one employer side person in the room or on the call, just to ensure that someone's coordinating the call, and then someone is assigned to take notes or just be a kind of second set of eyes on the management side, in case anything is ever questioned. As Lisa said before, these conversations are perspective based typically, so it's good always to have two people in the room if you have it available to you.
That's a really good point. Yeah, very good point. Also, assume the employee is recording it. So be mindful of what you're saying, right? I think when we're advising employees, a very big chunk of them kind of knew it was coming. When you get that email saying, hey, can we talk tomorrow at 9 a.m. and it's like a very unusual thing for that particular manager to do. They usually kind of know it's coming, or they start to see, some changes in their role, so people often aren't surprised. So more and more people, whether we all like it or not, they're recording. So, govern yourself accordingly and know that that's probably the case. I still don't love, I rarely advise people to record. I know sometimes it is a good idea, but it just feels yucky all the time, but we live in a world where I'm probably just sounding old fashioned at this point because everyone is doing it anyways. And also this also all goes without saying, this is for non-unionized workplaces. If you have a unionized workplaces, that is a whole different webinar and a very different approach to all of this, of course. Okay, let's go into the nuts and bolts. I'm going to hand it back over to you, Jess.
Thanks, Lisa. And I see that we have some questions rolling in. Do you want to review a couple before we move forward?
Yes, please. Yeah, that's a great idea.
So I see the first one that we have is, can you speak to mutual separation? And if that happens, if an employer does not need to pay the employment standards obligations.
Oh, that's interesting. Do you want to take the first cut at the answer?
Sure. So sorry, there's a car alarm going off. If anyone can hear that, I apologize.
No, your mic is cutting it out. I don't hear it. You're good.
Awesome. So I'll just about this one, I'll say, mutual separation is not a defined term under the ESA. As Lisa said, there's terminations, there's resignations, there's without cause and with cause. There's not a lot of, interpretive kind of going ons in between. So this mutual separation, it doesn't remove ESA obligations. The key question here, I think, would be whether the employee has chosen to part ways and has presented an opportunity to the employer to kind of, part ways amicably, or whether the employer has said, things aren't working out. How would you like to resign? And we'll, facilitate some kind of payment. So I think really, the instigator of that conversation is going to come into play a lot. And this is where documentation is really important. But otherwise, an employer cannot waive or opt out of their ESA obligations.
Yeah.
Lisa, what do you think?
Yeah, and maybe a way to think about it is, so maybe there is a third version. So pregnant, not pregnant, and then a third thing. So without cause, with cause, and then resignation. It's its own category. And you can put retirement within that, for example. It has to be so unambiguously clear, preferably in writing, that this person is expressly resigning. If they're just angry on a Friday afternoon and say, I'm never coming back again, there's lots of case law that says that's not really quit. That's just a anger. There needs to be a real specific, I am resigning. And so anytime you get that from an employee, always confirm in writing back, we confirm that you have resigned effective X date, and make sure that you close that loop to confirm the resignation. A mutual separation, we see more and more of that, and we are asked by employees to try and negotiate one on their behalf. There's that thin line between they're trying to quit and get paid to quit. So that is a really complex area, and it's so fact driven whether or not they're actually if the employer is triggering the conversation, it's likely a termination. I would say likely 100% of the time it's a termination if the employer is triggering that conversation. If the employee comes and says, look, you've been doing a whole bunch of trashy things to me, and I'm going to either sue for constructive dismissal or you give me a package, that's not quite resigning, right? Even though you need to resign for constructive. So it's a complex nuance. But if an employer is initiating any conversation about a mutual separation, you are looking at termination pay. And do not ever say, hey, would you like to retire? Would you like to hang out more with your grandkids? Would you want to go to the cottage more? Because now you're engaging in age discrimination as well. So be very careful not to do that. If an employee comes to you, fine, archive it and jump on that fast, because if they resign, unless there's something in your contract, there's no entitlement to pay. But we are seeing more and more people kind of lingering on, waiting to be fired so they get that extra many months of pay instead of just quitting as a resignation or as a retirement.
Yes, great point, Lisa. Okay, so I see another one came in from Lena. What if we've already put someone on a PIP or coached them, and then they go out on a mental health related leave? I'm assuming during the PIP, which is performance improvement plan, for anyone that was wondering. So I'll kind of have a first go, and then Lisa, if you could say your thoughts as well. I always see it as, if someone goes on leave, that's a entirely separate, going on than the performance management. And so any PIP should be paused. Any PIP should also be reviewed to ensure that there's no suspected correlation between the reason for the performance improvement or the performance management and the subsequent leave. And then just in general, employers should not proceed with any terminations during a leave while on PIP. It's very rare that those things are justified, if ever. So it's usually very, very good to kind of separate those things entirely. And then upon the employee's return to work, you can then reassess whether you pick back up on the PIP or whether, an accommodation might be required. It's really, based on specifics, but I see it as two separate going ons. So what do you think, Lisa?
Yeah, I agree. But I would say right now is probably one of the most complex areas of employment law that we're dealing with. People who are having performance issues and then claim a mental health leave. And so these PIPs and a leave often are increasingly going hand in hand, and it's a bit of a chicken or egg sometimes. Was their performance being caused by the mental health issues, or, was their poor performance stressing them out and causing a mental health leave? Who knows? And it actually doesn't matter if they have a valid doctor's note saying they need a leave. So it's highly sensitive when they come back. Now, if you were in the midst of thinking about firing them, now they're on a medical leave, unless you have a super awesome, clear performance record that is completely unrelated to a mental health leave, and issues that might arise when someone has a mental health issue, which, I don't know, that's such a subjective, messy area. And I think no employer or employment lawyer should be making conclusions on any of that. That's an individual experience between the person and their doctor. But it is increasingly common and a really big challenge for small employers, for sure.
Mm-hmm. I would agree. Okay, maybe we'll continue and then get back to questions just to keep things moving.
Sure. Can I just do one more quick one? Is it legal for the employee to record? Yes, if they can't record other people's conversations, but as long as one person is in the conversation, they can record. Is it a good idea? Is it tasteful? Is it undermining your credibility down the road. Who knows? Those are all different things, but it's not illegal for an employee to record a conversation that they are in.
Yeah, great.
Yeah,
Flag.
we can come back to some of the other questions. That's a great idea, Jess.
Sure. Okay, so now we'll move on just to ensure that we're covering all of our bases here. So we'll review some legal concepts around termination, including what the law requires, different types of termination, and we'll go through how contracts can be applied or invalidated just briefly. So in Ontario, if you're ending someone's employment after 3 months, right after 3 months have concluded, you must provide written notice or payment in lieu unless there's justification for a just cause. And so the important thing here is just cause is an extremely high standard under the statute. So to withhold someone's statutory entitlements upon termination, there's actually no defined just cause. It's willful misconduct, disobedience, or willful neglect of duty that's not trivial and has not been condoned. That's all legalese, but just to say, it's not enough that someone's not meeting expectations that you've reviewed, or even if they've made some mistakes, there has to be a willful misconduct. It has to be a neglect of their duties, a willful neglect, which means you have to have made them aware repeatedly, given them an opportunity to improve, and they have to have neglected that entirely and chosen instead to continue with their bad behavior. So absent that very high threshold, most terminations will require notice or payment in lieu. And we'll get into kind of the semantics of that. So additionally, employees without a valid employment contract, may be entitled to common law notice. And so just quickly to run through, there's statute-based notice under the ESA that's required to be given. It's about a week per year of service, up to a maximum of 8 weeks. So that's notice or payment in lieu upon termination. Now, absent a valid contract that limits those entitlements to those ESA minimums, an employee would be evaluated in a court based on things like age, years of service, the caliber or level of employment, the availability of new employment, any other factors that might influence their reemployability, and then, determined to have quite a bit longer notice period likely. We often see almost 3 to 4 times what they're entitled to under ESA, potentially more. And so, employees that have a common law entitlement, so an invalid contract, that liability could increase significantly. And we see that as one of the highest costs that employers have to endure with their employees typically. So we'll go through a little bit more legally. So willful misconduct versus just cause. So you'll notice I said before, just cause, under the statute, there's no just cause. It's willful misconduct. But more generally, there is a concept of just cause. So there are certain situations where an employee might be entitled to their ESA minimums, their Employment Standards Act week per year of service, but their conduct will have disentitled them from any further claim. Now, this is a purely legal argument, just as common law entitlement is. So if you start to get into those conversations, we highly encourage you to seek legal counsel. We can help you with these conversations and working through what all of that means. So just to give a kind of a rough comparison. So things like, deliberate theft, fraud, they could qualify for willful misconduct, although we've seen in certain cases that when there's a reason for doing so, such as when someone hasn't been paid for a month, or, there are certain situations in the case law where, theft might not be enough to establish willful misconduct. But typically, it's very serious, very intentional disobedience or misconduct that would maybe meet, the willful misconduct threshold. Things like repeated lateness, general incompetence usually does not meet that willful misconduct standard, and that's when we would typically advise to proceed in a without cause termination. So we'll move forward on why termination clauses typically fail. So this is, something that's very highly contested. We see in the courts the applicability or the enforceability of termination clauses. Now, it's not only termination clauses or the clauses that speak only to termination in the contract that are evaluated. It's anything that might contemplate or might come into play during a termination. And not only that, it's anything, if you're proceeding with a without cause termination and your contract is compliant in that specific scenario, it still might not be compliant overall. If there's any scenario where that contract might limit an employee's entitlements upon termination for any type of reason, it could be invalidated. Even if you're not, terminating for willful misconduct just cause, even if you're not, in that specific scenario, any language that purports to limit an employee's entitlements could be invalidated in a termination scenario. And then what I mean by invalidated is that the employee would be, operating under no contract, under no valid contract, and they would be potentially entitled to those bigger common law assessments. So we see, general ESA compliance errors as I went through. Issues on how things are rolled out during a termination itself. So vacation payments, benefit continuation issues, overly restrictive language from the employer that limits an employee's rights, which they are not able to do. The employee has those rights regardless. And then any outdated templates. The law is changing so frequently in employment law, and it's retroactively applied if it's an interpretation issue. So just because something was valid in 2024 or even 2025 doesn't automatically make it valid language in 2026, unfortunately. So we often have to revisit these yearly and just ensure, just a quick once over to ensure that there's no outstanding liabilities in the language that you've signed with an employee. So we'll move on to this ESA only language, which we often see, and it's highly scrutinized in court. And what I mean by ESA only language is a lot of the templates that we come across, and most recently our own templates have had this language and do have this language, this savings language. In all cases, the employee will receive everything they're entitled to under the ESA. That's great to have in there. However, if your contract clearly and is ambiguous or clearly limits or disentitles an employee to something they otherwise would be entitled to, the court will likely just not even look at that. In all cases, this employee will be entitled to their ESA minimums. Because what are the ESA minimums? The employee might not know this. It's up to the employer to really have a firm grasp on what the employee is entitled to and ensure that those lines aren't breached, or there's no assertion that the employer can give less than the employee is entitled to in those scenarios. And so any language that purports to limit or disentitle an employee to their rights, it could be seen as invalidated regardless of that saving language. In all cases, you'll receive XYZ. It's not enough to save an otherwise unenforceable contract.
Mm-hmm.
And so,
go ahead. Go ahead.
I was going to move on.
Go ahead.
I was going to move on to severance. So if you,
okay, can I just make one comment then, please, on this? I just want to zoom out for a second, just to be clear. in all employment law situations, really across Canada, but we're focusing on Ontario for this because of some of the legislative stuff. Every employee who is being fired, unless it's with cause, which is a tiny percentage of the time. So for all the other ones it's without cause, they're always entitled to something. And let me just quickly zoom out and say, the Employment Standards Act always sets this basic minimum that no matter what, this employee gets this basic amount, and it's tied to the number of years up to the number of up to 8 weeks, as Jess said, and she's going to talk about severance in a second. But there's this basic that an employer is required to either give notice or pay in lieu of that notice. So that's the minimum amount. At the other end of the spectrum is the common law. So what a court would award. So if the employee sues you for wrongful dismissal, here's the package they'll get. That amount is way higher than anything that's in the Employment Standards Act. Somewhere in the middle are all the contracts, right? That we hope are enforceable. And so the contracts help contain it to have some sort of balance between these two. But there is a spectrum of what an employee is entitled to, and that interpretation and the default, if there's any ambiguity, any small drafting errors, it always goes to the employee because they are the vulnerable party in this scenario. The employer drafted it. So it always gets construed against the drafter when you've got a vulnerable employee. This is old law. And so this is why it's frustrating for a small employer. Your employees will always win if there's a tie going on because of the way that it's interpreted. And so you want to have either the contract in the middle or the ESA only. Otherwise, you're wide open to this wide amount that the court is going to award. So I just wanted to lay out that basic framework that I think most people know at this point, but just as to sort of tie together why ESA only. Certainly that's awesome if you can get there and that's what you want, but it's not what your employees want, and they will fight hard to overturn that contract.
That's a great addition, Lisa. And even this carries through to all of employment law. The employee is also always the vulnerable party. And so the laws are created in employment law to protect them. And so it'll always default to protecting the employee if there's any ambiguity in interpretation of anything. So it's a great thing to flag. Okay, so we will move now on to severance pay, which is very confusing concept because Ontario is really the only, province that does this whole termination pay and then also severance pay potentially. So what does it mean? Severance pay is a separate and additional payment that an employer might be required to pay, and we'll go into what qualifies an employer as a severance employer upon a termination. So in addition to the termination pay, so in addition to that 1 week per year of service up to a maximum of 8 weeks of notice or payment in lieu, that's termination, that's separate. Severance, additionally, if an employee has 5 or more years of service and the employer has a $2.5 million payroll at the time of termination, or potentially in a mass termination, there are specifics that would obligate an employer to pay severance regardless of their payroll. Severance payment is a week per year of service up to a maximum of 26 weeks. So, your 27-year employees would only be entitled to 26 weeks of severance pay if you are a severance employer. This is a lump sum payment, although it can be agreed upon termination if the employer agrees and the employee agrees as well, in installments, weekly, biweekly, monthly. You can kind of prorate that. But either way, sorry, I'm reviewing to ensure that I didn't skip over anything. But either way, severance is a separate obligation in addition to the termination pay. So it's not, the 8 weeks and then plus, up to 26. It's that termination pay and then separately a week per year of services as severance. Okay, I'll pass it on to Lisa to final comments on severance as well as some resolution strategies going forward.
Sounds good. Yeah, severance pay can really trip up an employer. It can be you just need one outlier employee who's been with you for 30 years, and it transforms their package. They're now automatically entitled at law to almost 7 months. And so if you're negotiating for something super generous and you think 8 months is generous, no way. Like it's barely hitting the minimums. We had some questions about how to deal with national contracts. So this is a good example of where having someone help you that understands the nuances of the different provinces. So Ontario is the only one with severance pay for provincially governed employees. The federal jurisdiction has a little baby version of this, but the Ontario one is the big one that really, if you're an industry that's provincially governed across the country, then you need to keep an eye on how your Ontario employees have this additional entitlement. One of the questions that got asked was, we have locations across Canada and don't have language in our termination clause indicating they're not entitled to common law. Can we add that language and will it be valid? So, and then as someone else asked about rolling out updated contracts, basically. It's tricky to do. It's a great idea still. So it's just, it takes a little bit of careful planning. And so in order to roll out a new contract that has an enforceable termination provision, and let's say you are a workplace that either has super old contracts or the termination clause has been set aside by the court already, or no contracts. If you roll out new contracts that have an enforceable contract, you are now taking away the employee's common law right to a big fat termination package. So that means in order for you to be able to rely on that, you have to give something in exchange for that consideration. It's called consideration at law. So either a signing bonus payment for this new contract. If you're about to promote someone into a new role, that is a really good moment to do it. If they're going to be getting a pay raise and a jump up in the role, that's also a good moment because you can tie the consideration of the promotion to this fresh contract and the termination provisions. If you want to roll out, say, an extra week of vacation for the person, that could work. If it's someone that's been with you for 35 years and you're removing their, probably 2 years of notice that they'd be entitled to, giving them an extra day off a year will probably not be enough to compensate. But strictly at law, and this is like the most annoying answer that lawyers always give, it always depends. The courts are not actually coming down yet on exactly how much consideration is sufficient. So it's a wee bit of a guess all the time, but it needs to be sufficient to justify taking away the common law. If they're an employee who's been with you for 2 years, you're not taking as much away from them, so the consideration can be a bit less. But transparency and pointing it out that, oh, by the way, here's your new contract, do take a look at the termination clause, point it out, because otherwise if you try and sneak it in, then that will absolutely be construed against you in the future. Anything to add on that consideration issue, Jess?
No, I think you did a great job of covering it. I will just add regarding the calculation of severance, just to be clear, it is a global payroll. That is, I just reread the question that we got, and I think that's what the question was leaning towards. So it's not just the Ontario employees that you pay, it's globally calculated payroll. And that was case law determined that a few years back.
Yeah, it changed quite a bit because it used to be just establishment in your little local municipality, but then all of a sudden it became all over the place. So it definitely has changed things there.
Yes.
Okay, in the interest of time, I'll zip through the settlement strategy, what actually works. So let's say you've now had to fire someone and they've consulted their lawyer ChatGPT and they're now pushing back, or they've lawyered up. I mean, it's a vibrant area of law for sure. So what are some settlement strategies to avoid the cost of litigation? So certainly one area is have reasonable opening positions. If you're putting on so little on the table and the termination clause is not enforceable and they're entitled to 2 years and you offer them up, half a year, you're just inviting them to fight. So having a reasonable opening position is good. I think strategically it's also good because it starts to there's this diminishing returns on them lawyering up and spending all this money on fighting if they're so close anyways. I mean, if all the parties can avoid the cost and hassle of litigation and a minimum $50,000 trial, then there should be a bit of a discount on what they're, that's the employer argument, there should be a bit of a discount on what they're getting. And so having that reasonable opening position is going to really help with getting to a settlement strategy. Having clean, neutral documentation. You don't go on and on in your termination letter about what a horrible person they were, because that's going to get you nowhere. Lots of consistency across your communications, and then know when to stop arguing. So this is the other reason why I think termination meetings should be 5 to 10 minutes maybe, because every employee, it's human nature. We want to know why. Why is this? And then we want to start defending ourselves. We want to start explaining. But that decision has been made. And so there's no point arguing about this anymore. All we need to talk about is how much money you're going to get or how much notice you're going to get, not about the decision itself. And so separating that out somehow, it's hard because, you know, everyone's emotionally charged when they are fired. So that's a tricky one. A final comment here around reference letters and confirmation letters. You know, stick to neutral facts. Never say negative stuff in a reference letter. If you're going to say yes to a reference letter, make sure that you are comfortable giving that reference letter. There's no benefit to you as an employer of trashing. I mean, the employee's not going to use a letter, but even just, you know, in general, verbal references. You know, align with your termination rationale and try and avoid creating all these new post-exit risks. Now, this is where I think US and Canadian law kind of diverge a wee bit. There really isn't a great big line of cases in Canada where the new employer sues the last employer for writing a really good reference letter and this employee turns out to be terrible. For misrepresenting their skills. We don't really have that line of cases here. That is a thing in the States. You don't want to be dinged for misrepresentation as the terminating employer. I think, though, in the big picture, help your employee get to a new job. Help them mitigate their damages. It's not just about being kind, which should be the biggest reason. It's also about saving yourself the cost of them being unemployed for a long time and all of this festering. Their new job becomes fighting you. If as soon as an employee gets that's happy in a new job, they've mitigated their losses, they've crystallized how much you owe them, but also it just brings all this temperature down strategically. So, you know, it's fine if your company has, and if you have US headquarters, it probably is the rule that you can only give, you know, a confirmation of employment. I really recommend wherever you can add an extra line or 2 or 3 of something that is truthfully positive about this person to help them get the new job. It helps you as employer to get them on to the next role. I have strong feelings about that one because people are so worried about the risk, but I just think the risk is so outweighed by the benefit of getting people to their next job and get everyone happy. It just makes all the difference. Over to you, Jess, for the last topic here.
I would agree, Lisa, and I'll go through this quickly. So just a kind of a checklist for you to move forward. So addressing issues early. Delay almost always makes things worse. Document consistently everything, notes, emails, you know, correspondence, even verbally. Plan terminations before you act rather than just reacting in the moment. And don't blindly rely on your contracts. They're important, but they don't fix a poor process or a poor termination etiquette. There is liability that exists with bad faith terminations as well. So if you remember nothing else, sorry, I'm trying to speed through.
No, sorry, I don't mean to rush you.
No, that's okay. If you remember nothing else, remember this. Most termination risk is self-created. It usually isn't about bad intent. It's just about the process. And so by the time you get to the termination stage, you can't fix everything that came before. You're just often dealing with the consequences of what you've done. Good news is that small improvements make a big difference.
Mm-hmm. Mm-hmm. And we're
That's it.
empathetic. All those small employers out there, you don't have a big department to do all these things. We get it. You know, it's this is the gold standard that you all need to have, but hopefully you can pull out some key pieces that will help with the headaches and the cost of terminations. We are at 11:31. There are a few more questions. We've tried to answer a bunch of them as we have gone along. We won't be able to get to all of them. Someone did ask if we offer a similar webinar for unionized environments, and that is a very good idea. I'm going to take that back and see if we can do something on that front. That's a great idea. I think we have to wrap it up at that point, Jess. Were there any questions that we haven't really at least partly addressed that we want to add in here?
No, I could talk about this all day, but I think we've fairly addressed this pretty conclusively. So yeah, I'll leave it to you to wrap up, Lisa.
Okay. Well, thank you, everybody. Thank you for all the questions. Please do feel free to reach out to us afterwards, and we are happy to give you a hand. And you know, go onto our website. We might have written a recent blog post on the topic as well. So go to our YouTube channel to see recent webinars that we've done that might also give you a hand. Thank you for all the good questions and the attention. Please join us for our next session, which is going to be episode 70 on May 20. We're going to be talking about AI in the workplace. I know AI is all the rage. We are a tech forward firm that knows a good amount about this. So we try and keep it very practical and fun, because AI and tech in the workplace is absolutely my favorite topic. So we will keep it fun and practical. So if you come to our website, you can sign up for it. We will announce it in our regular monthly newsletter as well, so that you can be reminded of the next session. We have a fantastic team. Feel free to reach out to any one of us if you have any other follow-up questions about any of this. We're happy to give you a hand. We only do employment law, so this is a topic we talk about every day and are happy to help you all out. So thank you very much.
Thank you, everyone.